Okay, now, how do you bring a petition when you want to bring a petition? Or if you're going to participate in this process? I'm going to ask Chelsea to pick up from here.
The people that bring the petition for the guardianship, known as the petitioners, the cost in the beginning, they are paying out of pocket. So no access to the AIP's funds. Everything has to be court approved. So when you're bringing a petition, you cannot use the AIP's funds to fund the beginning of the matter. So they pay up front. Within the petition, a guardian can be nominated by the petitioners. Often the people that are petitioning for the appointment of a guardian are the ones also that say, we will be guardian as well. It doesn't have to be like that. There is something in the mental hygiene law, Article 81, that allows the AIP to nominate his or her own guardian before this proceeding, if it's filed with the court. So today, everyone can sign a form and say, if I'm ever subject to an Article 81 guardianship, I want Bob, someone, to be my guardian. The court is then obligated to honor that nomination unless they think the nominee is unfit or the AIP has withdrawn that nomination before the proceeding.
So you can do the nomination in advance?
Yes, yes. So before any questions of capacity arise. Who can be a guardian above 18, no felony conviction. There is a preference for family members, typically, but as we just heard, family members do not always get along and are not always the best guardians. The case that's up here actually was a son and daughter were fighting who's going to be guardian over mom, and it is in the court's discretion, because there was such a hostile environment there, to say neither of you are going to be it. We're appointing an uninterested party. So typically it is family members that are preference, just because you're not meeting someone new. They've typically have known the AIP for a long time, but the court does have discretion to nix any family members and get a third party if it's most appropriate. Who can bring the petition? Who can be these petitioners? It's a very exhaustive list, and almost anyone. The AIP can bring his own petition for himself, families, someone residing with the AIP, and then the last all-encompassing someone concerned with the welfare. So you can imagine that it's very open who can bring it. Facility where the AIP resides, nursing homes. There was an article in the New York Times, I think now it's about 2 years ago, exposing and making Article 81 guardianships look like this awful thing that nursing homes are acting as petitioners to bring guardianship cases so they can get paid. Because they are named guardians of their residents, now have access over their bank accounts and can pay themselves. So nothing has changed yet, but there is a big push and also a push back to prohibit nursing homes from bringing these petitions on behalf of the residents. Attorneys as petitioners. So we do, as attorneys, have ethical obligations to act in the best interest of our clients. There is a section in Rule 1.14b that at the very end, a protective action that we can take on behalf of a client is to seek the appointment of a guardian. So we are included on that list. The petition, when you go to the court, what do you have to put in this petition? There was a sample, I think that Roy had sent them earlier at the end of last week, maybe, of a sample form petition. Basic information on who's bringing it, you, your name, your information, on the alleged incapacitated person, a history about them, and what you want. So as we talked about a little earlier, Article 81 are narrowly tailored. So if you went into court as a petitioner and said, I want control over everything with no other information, it's going to be thrown out. You have to specifically state in there the issues that the AIP has with respect to property management and personal management, if you're seeking guardian of both, and what powers you are requesting that will help them with those deficits. Now, under miscellaneous, we do have a few things that are not required to be in the petition. So the ones above are required to be in the petition, but we often find that you do want them. Request to seal the record. So by nature, by default, these are public proceedings. The courthouses are getting a little bit more strict. So if you went downtown to 60 Center and asked, can I get in the guardianship matter of so-and-so, they're going to kind of say, who are you and why do you need this? But by default, these are public proceeding unless good cause is shown. If you want this sealed for a certain reason, that has to be in the petition. Now, what's the reason that you would maybe want this sealed? If there's an ongoing criminal investigation against your AIP. You don't want all this information now public that can somehow harm that. A public figure, the Brooke Astor case. She was one of New York City's, the wife of one of the biggest philanthropists. To know that they're under a guardianship, have that sealed. Medical information is not required to be part of the petition, but if it's going to help the petition, so as Myra said, we had a case where a man was in a comatose, a prominent Manhattan doctor, and if his patients found out that he was possibly subject to a guardianship, that might not be the best for his practice or business. So if you get it under seal, it'll be then known as the matter of John Doe with an index number. So his name is not public on the info. Another thing you can request, provisional remedies, such as a temporary guardian injunction, temporary restraining order. A temporary guardian is important also with this comatose case that we actually had. By the time you file the petition, and we'll get to this in a slide or two, typically you don't have a hearing until about a month later. So you have now a month period where the papers are sitting in court and nothing's really happening. If something has to be done tomorrow, in a week, something on an emergency basis, you can request a temporary guardianship for that interim period. So for example, if you have a elderly woman who is on Medicaid and they have to do a renewal every year and that renewal is due in 2 weeks and you now have to do a guardianship that's not going to be appointed for, at least a month out, and you need someone to do that right now, you can request a temporary guardian, which is granted on a much more expedited basis before the actual hearing. So with this petition, you're going to file a petition and an order to show cause. Very statutory what the order to show cause has to have in there. Boldface, 12-point font. That's all in the law. Giving notice of this proceeding has to be done on a few people. On the AIP specifically, the person alleged to be incapacitated who this hearing is about, this must be in-hand service. Actually physically giving the papers to the individual. There was a case, it's a few years, now almost 20 years ago, but it is important. It's not the same as personal service under the CPLR, so it's not like you can give it to them or someone of suitable age and discretion at the place of their business, or if not, mail it in a thing. No, you actually have to give it to them. And I don't know how clear this is up here, but the comatose case that we were talking about, he was in a burn unit in a hospital. In a coma, burn unit, had to be served. So this is actually a copy of our affidavit of service. It's very small, but the thing that is circled in there, if you zoom in, says it was left at his feet, he was in a coma. And this still has to be filed with the court. So they are not willing to waive, it's still, you're still respecting the person's rights, not willing to waive personal service on the AAP. Who else has to be given notice about these proceedings? Spouse, parents, if the person is residing in a facility there, if they're receiving public benefits, they have to be noticed. Now, it's important that these individuals are only served with that order to show cause that we saw 2 or 3 slides ago, that will just give information on when the hearing is. They do not have to be served with the petition that gives all more the personal information, and this is more out of a respect for privacy of the individuals bringing the proceeding and the individual who is deemed to possibly be incapacitated. So what happens next? These papers are filed with the court gets them. Within 28 days, that order to show cause is signed by the judge and a hearing date is then set. The hearing typically is at the courthouse, downtown, or whatever county you're in, or where the AIP resides. A lot of times, individuals are in hospitals, nursing homes, and they cannot physically get down to the courthouse, but because there's a requirement that they must be at the hearing, quite often you do have hospital bedside hearings, and a judge and the judge's clerk and a court reporter will go up to hospitals, nursing facilities in order to have that hearing. The presence of the alleged incapacitated person, they are required, subject to exceptions, to be at the hearing. So if they are completely unable to participate, such as in a coma, or they're able to be there, but no meaningful participation will result of them being there, then their hearing is not required. Typically, of course, the judge does want them to be there, so the judge can make his or her own determination rather than just doing it based on the papers.